Hi, this is Erica Merrill, and I'm the founder of Perfect Legal Video. And I'm very excited to have with us today Attorney Nicole Reeves Lavallee. And today we are going to talk about an incredibly fun topic, and that is contempt. You always bring these fun topics to us on Friday, Nicole. Thank you so much. And welcome to the show.
I don't know that many of my clients would think it's fun, but okay, we'll see how it is. You tell me.
Well, I mean, who doesn't want to get your ex in line for not following the rules and making your life more difficult? I mean, I always thought that once you got divorced, it's like, wow, finally you can hold someone accountable, because when you're married or, not under some kind of a strict ruling, you really can't. No one's going to say anything unless you bring it up. So, I mean, let's talk about what is contempt, first of all.
Contempt is when the other party isn't following that court order. So you got it right on there. I always look at the people that are going, my ex is just torturing me because they won't follow the court order. So I usually get the people that are very upset about it, but I certainly can understand your position of going into court and going, hey, I want you to be held accountable. And that's really what a contempt is going to do, is try to hold that other party accountable for their inability to follow a court order.
So when can you file for contempt? Is there a certain number of times that someone isn't following a rule, or like, what is your suggestion, and what are the guidelines for this?
There's no hard and fast. Generally, the court is going to say when it happens 3 or more times, that's when you really should file. Again, there's some things that you want to be very specific on. Immediately, if it's, I lost my Christmas vacation, oh my God, you don't want to wait. I mean, you obviously can wait until November of next year, but do you want to wait? So those are the things that are going to hurt you more. Obviously, you don't want to be behind in child support more than a couple of weeks, and ultimately you still have to wait to go into court. So the court wants to see more than one repetition of something. Like I said, generally 3 or 4 times that something has happened. So again, non-payment of that child support, not dropping off the child at the right time, not having the visits allowed, something like that. Those are things that are going to be contemptible.
Why should you file for contempt? I mean, you could be one of those people that during your marriage or during your relationship, when the court wasn't involved, maybe you were just very easygoing and you're just like, late again, whatever it is. I'm doing all the work again. What's the difference now that there is a court order?
I think the issue is, again, how much are you going to put up with? You divorce this person or you separated from this person. You don't really want to have that relationship with them anymore. You want to move on. A lot of times the person that is in contempt is doing it for control. They want to continue to control you. So now that they're not married to you, they're going to control you in some other means. And it just happens to be in means that they know is going to hurt you the most. So again, I'm going to show up late for the drop-offs of the parenting time 20 minutes so that you're going to lose your job, or you're going to be threatened to lose your job, or your new husband is going to be pissed off and thinking something's happening. I mean, there's so many scenarios. I'm going to make sure that my child support happens to go in the mail, and I'll put it in at 8 o'clock at night, where it's definitely going to be postmarked the right day, but it doesn't get here for 4 or 5 days later. Those types of things that something's happening and you just can't stop it. You need to get out from under their thumb. That's the biggest thing, is because a lot of times it is a control thing. It's not just I'm being lazy. It's I'm doing this intentionally and I'm doing this to screw you. So when you start putting your foot down and going, enough is enough, that's when all of a sudden the other party goes, oh wait, they're not letting me get away with it. Maybe I shouldn't do that again. And it may take 3 or 4 or 5 times for them to get it, to understand that I'm done with you. I'm your ex for a reason. I'm moving on. I need you to do what you're supposed to do. And there's consequences to your actions. And that's really why you want to file.
I know it's funny, because sometimes you can feel like you're still married to them. Like the relationship hasn't changed. The same things are happening, and you let it happen by not filing for contempt. So we've talked about a few of the things. You want to hold someone responsible. What are some of the other benefits?
I think the other benefit is obviously knowing that again, once they learn that you're not going to be under their thumb, they will stop it for the most part. There's going to be people that are going to continue to do that. But for the most part, at some point, they realize, wait a minute, there's consequences for my action. And the consequences could be jail. It could be, paying attorney's fees. It could be stuff of that nature that, again, is going to hurt them in such a way that they didn't know that they could do. And ultimately, it could be that, we're going to take away custody because you're continuing to do this. So the extreme could be exactly that. I think the benefits are, again, from your perspective, you're getting out from under their thumb. You're getting what you want. Ultimately, the children are not being put in the middle of it, which is a huge thing, because that's usually what ends up happening is the children are in this ping pong ball between the parents, and we're trying to figure out who's right and who's wrong, because mommy's right, no, mommy's right, and it's back and forth, and you're going, what? Don't put those kids in that situation. So it takes it away from all of that and really kind of allows you to do what you need to do as a parent.
So the idea is to make things easier on yourself and easier on your child. I think that I know one of the answers to this next question, but it's, what is the burden? I mean, for me, it's like, I hate conflict. So what do I want? Like, you already put up with that stuff for that whole relationship. You don't have to live with them anymore. That's a big benefit. But, what is the burden of actually standing up for yourself and making sure that you're treated in accordance to, what you have written on your papers?
I mean, unfortunately, we're looking at probably a month's time frame from the filing date until you actually go into court. So that month can become very tedious. Because again, that's when your ex is probably going to continue to push and push and push and push and push. And maybe they'll also try to go, oh, really, Erica, this is no big deal. Why don't you just settle with me? This is a bogus case. Just dismiss it. Why are you even bothering? So they will also play on you, especially if you're non-confrontational, and go, we'll just bully her a little bit more and a little bit more and a little bit more. And that's where hopefully you have an attorney. You go, talk to my attorney. Nope, my attorney has to address it. Nope. And you can at least push it off that way. But again, in that month's time frame, they're going to probably make it worse for you than better. Sometimes everyone goes, oh my God, I did something wrong, and really try to correct it. Most of the times they want to torture you for that month period to get you to settle and to work with them and to see that they are right and you are wrong. So that's a burden. Obviously, you're going to have to pay your attorney for the filing of the contempt and to going in and representing you. The other thing is, if you do go by yourself, you've got to be able to speak up and articulate exactly what was willful and wanton and where the order is clear and unequivocal. And if you can't do those two things, you're going to lose on a contempt and that person's going to get away with it. So you really want to be able to have that attorney by your side who's going to know your case, who's going to know the facts of your case, and is going to be able to present it in such a way that the other party will be found in contempt and that there will be ramifications.
I mean, and that's very interesting. One of the things that I always feel, and what I've found out from being in court, is that really the court doesn't take things that you might take very seriously. They don't think it's that important, like how the kid is treated on their time with the other parent, for example, that what happens on that parent's time happens on that parent's time, and that's that. And unless the kid is in danger, they're probably not going to do anything about it. So are there a list of things that the court feels is appropriate to hold people in contempt for, or what's a waste of time?
I think the waste of time is parenting styles. You're never going to get somebody to agree to your parenting style. You married this person, or you had a child with this person. You separated with this person. You separated probably because you had difference of opinions. One person's a slob, one person has OCD, one person doesn't care about finances, the other one absolutely has to pay all their bills on time. You're going to have differences of opinion. And I think you hit it right on the head, is that, guess what? If there are those parenting style differences, nobody cares. Now, parenting style differences that might matter is, well, I let my kid stay up till midnight or 1 o'clock and he's 5 years old. Well, that might be a little bit of a problem. But again, we need to be able to show that problem. And that problem is going to result in child's sleeping during school, the child's acting out at school, the child's taking naps at school. Those are the way it's going to affect it. So again, if it's, I just let my kids stay up, 3 hours later than at mom's house, nobody cares. If there's no consequences, we need to look at what those consequences are. So not necessarily parenting styles. We have the same thing with, well, you're not feeding them the right food. Okay. Well, guess what? Me, all I eat is chicken nuggets. And why would you think that I was going to feed my child anything other than chicken nuggets? Because that's what I eat. And so you have that situation where they're not going to change their style. So again, unless you actually put something in an agreement, and more importantly, you can prove, which you never can, what that child is actually eating or what that child is doing. Yeah, you're going to be able to say, make sure the homework's done. Okay, well, that's a good test because we can know the next day when the child gets marked off for homework not being done, we know, oh, wait, it was dad's day and child homework wasn't done. Okay, great. Something that we can tangibly look at and say unequivocally, person didn't do that. Now, again, is it going to be homework wasn't done? Well, it wasn't done at dad's house, but then he came home to mom's house and mom did it. And then so the homework's done the next day. Well, then guess what? There's no consequences because we can't prove it. So really, we got to be able to have that provability. So it's going to be, you showed up late. Again, do we have a text message? Do we have an email message? Did you go into the grocery store and purchase something waiting for your kid to come? Like those are the things that we're going to be able to show tangibly that it was done. Obviously, child support payments, if it's done through DOR, that's easy enough. If it's done directly, then again, we're going to say, well, what was the date of the check? You're going to need to make a copy of that check. You're going to need the front and the back of it, so we know when it was endorsed. We got to make a copy of the envelope, so showing what the postmark is. So we have a whole bunch of things that we have to lead up to prove it. So again, it goes back to, if it's parenting styles, chances are you're not going to win a contempt. If it is something that parenting styles that result in bad behavior, bad grades, bad something as a result of the child's actions because of a parenting style, then the court will look at it.
Does it ever end up being a he said, she said situation where you have to do more to prove what's actually happening?
Absolutely. I mean, again, I think the homework is probably the easiest one or the hardest one to prove, because if we have a rotating days, unfortunately, we have firefighters that usually have 4 days on, 2 days off. So we're never going to be able to do that unless you're going to subpoena the records. They're not going to admit that that was their day. So again, if you have a set schedule every Wednesday, okay, well, every Thursday, this homework's not done. That's easy enough to do. But a lot of times it does become a he said, she said. And that's why, again, if it's parenting styles, it's going to be harder. If it's, well, he showed up 10 minutes late. Okay, well, what proof do you have? Well, because I know, I wrote it down. Okay, and he says he wasn't late. So again, what do we have to prove that? Maybe it's that we're going to go, hey, you need to record a video by your house saying that they showed up at the house. Like, give me something of substance. So a lot of times the he said, she said will result in the judge not finding a contempt and maybe ordering them to do a better job. Maybe it's ordering a tweak of the court order so that we can protect that child in whatever way possible. So we tighten up that language for you so that hopefully this issue will resolve itself, because both parties say that they're going to resolve it. So it really depends.
Do you want to speak a little more about like what the results can be? Is there anything else that we missed? Because I know the questions that I was asking, I didn't quite get around to that, but I know you've answered some of that question.
Yeah, ultimately, the biggest thing is obviously, can I get my attorney's fees paid? The answer is I don't know. So if the judge finds that you are in contempt, then chances are you're going to get an award for attorney's fees. Now, are you going to get the full amount? Really depends on how long we were sitting there. Really depends on the judge. Some judges are going to go, okay, standard amount is this. Other judges are going to look at the affidavit and go, yep, I'm going to give you all of that. So it really depends on where you fall in the scheme of that in terms of attorney's fees, and whether or not the judge is going to order a date certain for those attorney's fees to be paid. Maybe the thing is that, again, you missed that Christmas vacation, you're going to get the Christmas vacation the following year. So you're going to get both mom's time and dad's time. So you get the whole Christmas because you lost the whole Christmas previous year. So something of that nature. Sometimes it's just, hey, I missed 3 days of parenting time because they went on a vacation and they didn't tell me, and it was my days. Okay, again, we're going to make up those days over a period of time. Hopefully that's going to be something that we can agree on. But if we can't, the judge is going to ultimately decide that and make a determination. So it really depends on what the issues are. Obviously, if it's child support, we're going to set our arrears. You owe us your child support. In addition to that, you're going to be paying us $25 extra a week until it's paid in full. Multiple times of doing these things can ultimately result in jail time. So the judge can incarcerate you. The judge is usually only going to incarcerate in financial issues. Again, the judge can take away custody if they find out that what your actions are alienating the other parent. I'm not going to allow him parenting time because even though you, judge, said that, dad was safe, I don't feel dad's safe. Okay, you're not the judge. Guess what? That can ultimately lose you custody. So the ramifications can be very great, or they can be very slight, again, depending on how many times we file contempt, what the charges are, and whether or not we can get a quick and easy resolution, such as the weekly arrears or the makeup time for the next holiday, or is it something more gross that we really have to come up with creative long-term solutions?
I mean, it's definitely interesting you say that, because one of the most frustrating things about separating from your partner is that you used to have the say over your child, and now you don't. You have no idea and no control over what's going on for a certain period of time. And sometimes it's scary. I mean, but you have to ask your attorney before you act. And I feel like that's one of the best things. Let your attorney speak for you in court. Only answer questions when asked. Don't make faces. Don't do all of that. Be respectful of everyone involved. But also, if things do come up, I think it's really important to have an attorney to ask their opinion and get their strategy, even in like the heat of the moment situations. You call your attorney before you go pick up that child because they called you crying from camp or something like that. I mean, you don't know. It's tough because you would have acted a different way when you were with that person, and it would have been fine. But you have to really, so everyone out there that is dealing with a situation like this, absolutely, if you're in the Worcester area or Massachusetts, give Nicole and her team a call, because they're fantastic at knowing how you should handle different situations and keeping you out of trouble with the judge. That helps your results.
Absolutely. And I think one of the big issues is, I do have those clients that call me up and go, hey, this just happened. What should I do? Like, I'm in the middle of a situation and mom is screaming at me and she's saying I should give the children to him, and the cops were called and I don't know what to do. And so a lot of times I'll walk you through it right then and there. I understand exactly what's going on. Let's walk through it. I'm happy to talk to the police. I'm happy to, be able to show them the court order. So those are things that we can hopefully resolve sometimes when we're in the mix of it. So sometimes it's very frustrating and you're like, oh my God, I'm in panic mode. What the hell is going on? And if you don't have that attorney by your side, it's very difficult because you've got to make the split decision right now, and it might be the wrong one. At least if you can get your attorney on the phone and we can explain the situation, know what's going on, I can tell you exactly what I would recommend, and then you can proceed accordingly.
So the last question I have for you is, if your case is pending, how does that affect you? I mean, there are things going on that need to change in your mind, but these things in court take a long time. I mean, do they have temporary orders for these contempt cases, or do you just have to grit your teeth and bear it and wait?
I think it really depends on the case, and what we're going to do with it. But ultimately, sometimes we're going to consolidate it with the pending action. So a divorce or modification, we're going to consolidate it because we're going to address all those issues. It kind of has an underlining tone of the modification or the divorce or something of that nature. Other times we want the judgment right then and there, so we can say at trial on the divorce or on the modification, Judge, we had to file 3 contempts in this case, and Janie was found in contempt on 3 of those occasions during the pendency of this divorce that has only been outstanding for 12 months. I mean, that's huge. So again, it really kind of depends on what the issues are, whether or not it's something that we can resolve, whether or not it's something we want to just have the judgment on, or we want to resolve later on and just have that presented at trial and go, Judge, we have 3 contempts that are pending that are also tied in with this divorce, and they're addressing this, this, and this. So really one of those things that you want to talk to your attorney about, we want to strategize about and determine what is best for you.
Well, this has been very interesting and very helpful for a lot of people, because you think once the divorce is over that your frustration is over, but a lot of times that's when it just begins. So having this kind of advice from you is just a relief to hear. And we really appreciate you. Do you have any final words on this?
Again, I think the biggest thing is don't jump the gun. You're not an attorney. Sometimes you're reading that document, it's a court order, wrong. And sometimes I tell my client, nope, that's not how it's read, but that's what it says. No, there's a comma in between and there's something else, and you're just reading it straight. And so it gives a different tone. So really, if you have any questions about it, or if something's unclear, really talk to your attorney before you act. Know what that judgment really means before you start doing something or accusing your ex of doing something.
Well, that is great advice. Thanks again for coming on the show, Nicole. I hope you have a great weekend.
Thank you.
And thanks everyone else for watching. We will see you again next week.